Okay, good morning, everyone. My name is Ryan Dividock. I'm the supervisor for the Planning, Zoning, and Land Use Unit here in Oakland County. Welcome to today's virtual planners gathering, 2024 legislative and judicial updates. Just a few reminders, if you have any questions, please use the chat function in Zoom. If you have, and direct your questions to Jim Schaefer. Jim's going to moderate a question and answer session after the presentations. And also just a reminder, the session is being recorded and will be posted on our website shortly after the meeting today. So let's get started. It's my pleasure to introduce our presenters, Jerry Fisher of Fisher Consulting and Mike Compagnoni with Midwest Strategy Group. Thank you both for joining us. Mike, the floor is yours.
Well, thank you. I'm going to pull my presentation up here for everybody, make sure we can get it going, and we'll start from there. So, can't get this to work. There we go. All right. Well, good morning, everyone. My name is Mike Compagnoni. I am a lobbyist at Midwest Strategy Group. I love to joke that lobbyist is between lawyer and loser in the dictionary. So that's my initial comment for you about lobbying. But the fun thing about what we get to do is we get to work in Lansing on a whole bunch of different policy issues and policy areas, covering many different subjects. Our team is a team of 10, actually 11 full-time lobbyists. We're located about a block from the Capitol. We do a little bit of everything. We have about 150 clients in all different sectors, of which I watch or work on a pretty good chunk of. I do a lot of work in local government, personally represent American Water Works Association, the Michigan section, also the Water Environment Association. Do work with a lot of local governments in Oakland County and also with SEMCOG. We represent SEMCOG. And do quite a bit of work in the tech space and automotive and vehicle space as well. So probably one of my more interesting past things I've worked on is I've authored a lot of the state's autonomous vehicle statutes. So I wanted to start off real quick with a little bit of an election recap. And I know this is probably maybe perhaps a little bit of old news for folks, but broadly, Michigan shifted pretty hard to the right compared to where they were in the last election cycle or so. I think it's just very helpful to sort of give this context. But obviously, Donald Trump won the state along with sort of the other two blue wall states, Pennsylvania and Wisconsin, among several others. We did see Alyssa Slotkin eke out a very relatively narrow win against Mike Rogers. She won by about 20,000 votes. There were almost 5.8 million votes cast in the state. And just to mention this, it's a fun election note, the closest statewide race for MSU trustee, which was the closest statewide race, was won by 4,000 votes statewide. So you think about that, 5.8 million cast and 4,000 was the margin. So super interesting to see a very close election come down for some of these seats. We had 3 contested congressional seats. One thing that is important to mention there is that Kristen McDonald Rivet, who is currently a state senator, won her seat. That's a big one because it potentially creates a vacancy in the Senate, state Senate, which I'll talk a little more about. Probably the biggest thing that's impactful for our world and what you guys work on day to day is that the control of the state House flipped from Republican or to Democrat to Republican. Republicans held what was called a trifecta from 2010 through 2018 with Rick Snyder and the House and the Senate being Republican. That doesn't mean that you automatically get your bills done, but it certainly makes life easier when everybody's in the same party. We had divided government for a few years, and then in 2022, we saw a really big shift, partly with some redistricting stuff that resulted in Democrats taking control of the state House, the state Senate, and holding the governorship with Gretchen Whitmer. They've had that for 2 years now. That period is coming to an end. That often indicates a very intense period of activity that I'll discuss a little bit. Democrats held a very narrow, and that's your question of the day, is what does this mean for the coming legislative session? Well, I want to talk about what the session we're in right now, which ends at the end of the year first, and then jump a little bit to next year and what happens after January 1st. So Democrats have had a very narrow House lead, and that's probably the biggest thing to mention for their majority. There's 110 members of the state House. They are split 56 to 54. That is a very small majority. I've long joked in politics, there's no such thing as a one-seat majority. It makes life very difficult. You have to be perfect all the time. Everyone has to show up. They all have to be there. And Matt Hall, who's the minority leader and the incoming speaker-elect, has been absolutely adamant that his 54 members will not vote on anything, even the most bipartisan thing you can imagine. They will not vote on anything unless all 56 Democrats are present in the House. There are many, many unresolved issues. The last time Democrats had a trifecta was 1971. So just to put that into perspective, this is their last chance, in theory, for potentially years, if not decades. That means that there are 8 remaining days of legislative session, and there's about 800 things that are on the Democrats' priority list to get done before Republicans take control in January. And I do want to mention some of those. I've got a short list here. Some are actually already on the radar. We have the tipped wage, paid leave issues that have been, speaking of court rulings, Jerry could probably opine on adopt and amend and the way that went. But we are now going to be operating under a citizen-initiated law for that if the legislature doesn't make some changes to tipped wage and paid leave. ESTA, employee, as the acronym you'll hear for it. We also may see a budget supplemental. Regardless of who's in charge, people are usually loath to leave money on the books to have the other team spend in the coming legislative session. So they're probably going to see a budget supplemental to spend the remaining couple $100 to $300 million the state has on their books. It's also likely we'll see a lot of discussion on economic development. There's sort of like a big picture potential deal in the works that covers things like some mega sites that are out there, covers things like transformational brownfield and other big picture. SOAR is probably the biggest one that you are all familiar with or have heard of, which is Strategic Outreach Attraction Retention Fund. All of those things sort of are in the same orbit and are being negotiated right now, kind of behind closed doors with the legislature and the governor's team. The difficult part with those is that the Democrats in the House, with their 56 members, have 2 or 3 members who adamantly oppose what you or I would consider traditional economic development incentives, like cash incentives for business. That's very problematic. If they don't have a couple of those members on board, they need to find Republicans to do it, and that is difficult in this current environment. Short-term rental regs is on the radar. That's one that's been out there for a long time. I think the picture for that gets noticeably worse if Republicans take control next session. That's one. I'll mention remaining in this session, and I didn't want the font on the slide to be about this big, just because of how many unresolved issues are out there. But master planning, parking, that's been out there just for housing. There was an 11 bill package being led by a Democrat out of Grand Rapids. Some of it was quite controversial, a lot of preemptions in it. That's been pared back now, and there are actually a 4 or 5 bill package that's being considered in the House this week. One of them does change parking regs down to 1.5 spaces. It does some, I think, lot size, zoning lot size items. Doesn't seem to be quite as controversial as some of the other bills in the package. One of the bills actually would allow single staircase, which I think drew a lot of ire from the public safety community. I'd also mention we're looking, it wouldn't be a lame duck without an aggregate mining bill or bills. We've got a package on aggregate mining that's made a reappearance. That will be potentially difficult to advance, which is probably a good thing in the world of local government. It's something that historically almost every local government has opposed. And then I'll mention just broadly economic development. There's a lot of discussion with housing and transit also tied to that sort of discussion. So that's a little bit of overview of what we'll see in lame duck over the next 3 weeks. They will start session tomorrow. In fact, those bills on master planning, zoning stuff are going to be up in House committee tomorrow morning or tomorrow afternoon. And then we'll see 8 days of lame duck, basically Tuesday through Thursday till right before Christmas. The exception to that will be December 17th. The Electoral College is actually meeting at the Capitol, and for security, they're not having session that day. Also helpful to mention what's going to happen next year. And we are going to have a new divided legislature next year. So we're going to have a Democratic Senate, 20 to 18, Lieutenant Governor Garland Gilchrist is a Democrat, was the tie-breaking vote there. If they do have a tie, they are going to have a 58 to 52 Republican majority in the state House. So bigger than a one-seat majority gives Republicans a little bit of cushion if they lose a member or two on issues. But they've been very clear with the incoming Republican leadership that they want to do checks and balances, basically, that everything is going to, at some level, need to be negotiated. Republicans have already rolled out a $2.7 billion road funding plan that basically shifts a bunch of money that historically has been restricted with sales tax going primarily to education and to a certain extent to local governments, depending on your breakdown of the sales tax chunk. They want to shift all of that money to roads, and they claim it will be revenue neutral and they can backfill and all these other things. But also understand that that proposal takes corporate income tax revenue and blows up most of the governor's SOAR proposal as well. So the current funding structure for economic development for SOAR projects, it would be utilized under that plan for roads. So interesting note, definitely people putting sort of their markers out in the sand where they want to be going into next session. The one thing that I'll mention about a 58-52 majority is much like the Democrats having a 56-54 majority, that is not foolproof. If you have a couple members out or you have a couple members who don't want to get there in an issue, that becomes very problematic. And I'll mention particularly that House Republicans kind of have a little bit of a microcosm of DC going on, where they have a chunk of members that are part of a Freedom Caucus type group, where they're very, very conservative. They rarely vote yes on stuff. It's going to be very difficult to get those 2 to 5 members to yes with all Republican votes all the time. So something to mention, they might run into some of the same issues that the Democrats have had this session going into next session in Lansing. I do want to just take a quick moment and mention, I know a few minutes ago, I talked about Kristen McDonald-Rivet in the state Senate. She has been elected to Congress. She'll be succeeding Dan Kildee in the Flint, Saginaw kind of Bay Area. And that will suddenly make a shift in the Senate to 19 to 18 until there's a special election to fill that. Senator McDonald-Rivet was probably one of the Democrats' most vulnerable incumbent members. She'd probably be one of the top 2 seats most likely to flip in an election. In a low turnout special election environment next year, I'd be very concerned if I was a Democrat about that seat flipping to Republican control, in which case you have 19-19 in the Senate, and that puts you in a potentially tougher environment to advance legislation for the next 2 years in the state Senate. The Senate was not up for election this last go around. They will be up for election in 2026. They're on 4-year terms, as will the governor and our 2 other constitutional offices. The last probably big picture thing I'll mention, before I wrap up and or open for questions, is we're looking at, really next session being a much more bipartisan legislature, right? The only way you're really going to be able to get things done is to probably have some level of bipartisan support of your bills. You're going to see a lot of work continue on criminal justice reforms. You're going to see a lot of work on economic development and what incentives should look like. That's particularly true for housing. I'll mention that. I'll mention that there's a lot of discussion out there on what is the best practice to get some of these things, squared away on economic development. And a good example of that would be short-term rentals. We hear a lot about how STR impacts the housing market, probably negatively for people who are like single-family homeowners. How does that play into, Republican versus Democratic plans to improve the housing situation in the state? I'll mention infrastructure, maintenance and funding. So whether that's water infrastructure or roads, traditional roads, it's been very clear that House Republicans, the incoming Speaker-elect, has, put that $2.7 billion roads plan out there. They want to have a serious conversation about, how do we fund roads? How do we fund our infrastructure? That's going to be something that will be subject to an incredible amount of negotiation, but at the end of the day could potentially be fairly bipartisan. And then, I know I talked a little on housing policy, but that's something that I think Republicans and Democrats both see an ongoing need for. Probably my biggest fear there from a planning perspective is that things like local control are going to have to, at some level, potentially be negotiated away. And that's a big thing that we're sort of watching going into lame duck and going into next year. The one thing I don't have on this list that I would probably add, Republicans have been pretty adamant about doing work to the state's energy and solar siting law. That's something that was very controversial that passed earlier this legislative session with almost solely Democratic votes. It's going to be an interesting thing to watch, and the reason is that the utilities to hit their goals at some level are probably going to need to keep some of these locations that they're working on and be able to have them. The flip side of that is Republicans are actually siding, I think, a lot more with local government on this, that, hey, people should have more say about what goes in their communities. So it's an interesting issue that I'll mention is out there. Obviously, there's some attempts to change that through ballot initiative that were unsuccessful, but that energy and solar siting law is an interesting note. I would comment that if you're on the south end of Oakland County, you're probably not going to be in an environment where you're worrying too much about those, just because the land requirements and things like that probably are issues a little bit for folks that are slightly more rural or suburban. So that's a crash course in what the next probably 3 weeks and or next 2 years will look like here in Lansing. But I'm more than happy to answer any questions, or I don't know if Jerry, you want to speak at this point. I tried to run through quickly on this, and if that was too much information, I apologize. But we're certainly coming into a very intense environment. Please don't hesitate to drop me a line or even a text. I'm happy to answer any general questions folks have, and feel free to take down my information and drop me a note. I will do my best not to text anyone from 2 a.m. at the Capitol in the next couple weeks. So see how it goes from there. Jerry, I'll turn it over to you here.
All right. Good afternoon, everybody, or I guess it's still good morning. Nice to be with everybody and join the Oakland County Planning Department, which is one of the best in the state, of course. And it's good to work with everybody, and I'm very heartened to see the great turnout that we have this morning. So I'm going to talk about a 2024 update on various cases and one instance of legislation. And I'm kind of crossing over into Mike's area a little bit, but it'll give me an opportunity to spend a little extra time on that. And so for those that don't know me, I am a former local government lawyer. Used to represent cities, villages, townships, and counties, and then I taught a law school for 15 years, and I couldn't stand it any longer, so I came back to practice so that I could be with all of you. And so now I'm a local government consultant. I do some general counsel work for local governments and mostly special counsel work, and represent individuals. All right, so with that, we will move forward. I'm going to be discussing a couple of U.S. Supreme Court cases that have come up in this recent cycle. One on sign regulation, one on exactions, which is a special form of takings law. The hot new dispute on wind and solar, which Mike touched on as well, that may get further attention. A Michigan Supreme Court case on the conditional rezoning section of the Zoning Enabling Act, and then diving into the lame duck session again, where certain legislators are attempting to rob an attempted robbery of local control in this area of gravel. So the first item is the Supreme Court case on sign regulation, and as many of you will remember, back in 2015, the world was going along just fine in terms of a nice equilibrium of sign and billboard regulation in local zoning ordinances, and a nuclear explosion occurred in 2015 with Reed versus Town of Gilbert being decided. And in that case, the court gave a very expansive reading of the First Amendment requirement for strict scrutiny, and it really isn't in the amendment. It's the court's interpretation, strict scrutiny of any bills that get into content regulation of the First Amendment, which essentially results in invalidation of an ordinance. If you get into strict scrutiny, there are very few regulations that survive that kind of scrutiny because of the required proofs that must be shown. And so as we went along from 2015, there have been many cases, and the city of Troy was involved in a couple of cases, billboard cases, and they had a rocky road, and a case finally made it back to the Supreme Court on the distinction between, it's distinction made in ordinances and regulations between on-site signage and off-site signage. And the way that was pitched by the sign and billboard industry was, well, look at, in order to determine whether this is on-site or off-site, there's a need to read the billboard itself. And if you need to read it, we can make an argument that means that it's a content regulation. And we know the regulations have to be content neutral, and therefore you have to give it strict scrutiny. Well, the good news is that that in this case, the city of Austin successfully argued with the help of great amicus curiae that that is so far beyond the pale that for example, the federal highway beautification statute makes a distinction between on-site and off-site regulations. And so the court essentially rejected the determination that was made in Austin in the lower courts, and has rejected the idea that need to read results in strict scrutiny. And just as a quick note, the Scenic Michigan participated as amicus curiae in that case, and I had the great pleasure of being the one of the liaison individuals for that situation. The other U.S. Supreme Court case involves this exactions rule, and this is Sheets versus County of El Dorado, and that's in California, and that's April of 2024, very recent. And the background for this is in the 1980s and 1990s, there were two companion cases, Nolan versus California Coastal Commission and Dolan versus City of Tigard, familiarly known as the Nolan-Dolan cases. And in those cases, which have been supported in follow-up litigation in the U.S. Supreme Court, the holding was that when you have an administrative decision being made that requires a property owner to give land or pay money or something of that effect in exchange for getting their approval for development, that triggers a requirement by the government to come forward and show two elements in order to validate their regulation. Element number one is that there has to be an essential nexus or a connection, a relationship between what the property owner is doing and the need for the regulation. And second, that there has to be some rough proportionality, that you can't put too much burden on one property owner to achieve general government objectives. And if the government fails to make that demonstration, that two-part demonstration, then the court will find that that is an exaction, an unlawful exaction, which is considered to be a taking, which invalidates the regulation entirely. So what happened in the Sheets versus County of El Dorado case was that as a condition to receiving a residential building permit, George Sheets was required, this is a single family home, by the way. George Sheets was required by the county to pay $23,420 as a traffic impact fee. Now, so this is part of and the unique part of the case, and $23,000 for a fee for a single family residence, of course, you know that El Dorado is in California. So the fee was part of a legislative plan enacted to address the demand for public services spurred by new development. So you can, in some respects, sympathize with the government that they're being overloaded with burdens of new development, but on the other hand, to impose a $23,000 fee for this one fee, I'm sure there are many others, for the construction of a single family home is pretty outrageous, especially considering that the amount of the fee wasn't based upon the traffic impact or otherwise attributable to the project, but basically assessed based upon a rate schedule that took account the type of development it was. You think that would mean it was lower, a lower fee, and its location within the county. So the court basically upheld the application of the exaction rule for the first time to a legislatively authorized requirement for a fee or a payment or a giving up of property. So this is a new thing, and the local governments need to be very attentive to this, because there are many instances. I mean, let's just take a woodlands ordinance similar to the one that we had in Canton Township, where there's a general requirement to plant new trees without regard to the action taken by the property owner. Those are the kinds of things that will be on the radar screen for this purpose. Now, wind and solar litigation, and Mike pointed out that the legislature may not be entirely finished with this process of legislating here, but in a series of amendments, including this MCL 4601223, and I'm paraphrasing here, a local unit, if a local unit has a certain type of ordinance, and it's a restricted kind of ordinance, it must approve or deny an application for a wind or solar facility with 120 days after receiving it. And if the local government does not have the ordinance in place, or if it fails to properly approve the application, then the commission steps in and preempts the local control. The local unit of government loses control. So what happened was that the Public Service Commission, in response to the statute, issued an order on how it was going to administer these provisions. And it is alleged in a lawsuit filed by 72 communities in Michigan a month ago to effectively rewrite the statute. In other words, the allegation is that the Public Service Commission is not implementing the statute, but trying to rewrite the statute in a manner that is at odds with the statute itself. And so the lawsuit claims that this Public Act 233 allows a local zoning jurisdiction to retain control over relevant siting decisions only if the jurisdiction has a compatible renewable energy ordinance as defined in the Act, and that the ordinances as required in the statute can be no more restrictive than the provisions of the statute. The claim by the property owners is the Public Service Commission changed the requirement of the statute. And so this is going to be an interesting fight that I don't think will end. It's an original action in the Michigan Court of Appeals, and I don't think it'll end there, but it's conceivable that the legislature will step in and take other action. All right, we're going to now stop over to the Michigan Supreme Court, and a very interesting case was filed in Mayfield Township over in Lapeer County. Joe Stock versus Mayfield Township. So we have this statute, this provision in the statute, MCL 125.3405, that specifies that a property owner may, in connection with a rezoning, may ask for a site-specific use that is going to be binding upon the property owner. And if the local government approves the rezoning with the condition as proposed, then you have a site-specific use that is part of the zoning ordinance in that case. And essentially what was involved there was that the applicant had a non-conforming use racetrack, vehicular racetrack, and was very limited in what they were doing. They asked for an expansion of the rights that they otherwise had as part of a rezoning to another zoning district. But that zoning district, it was very questionable whether that zoning district authorized these tracks at all. And the local government approved it. And so the court was challenged on whether or not, by a neighboring property owner, was challenged on whether or not there was authority to make this approval. I think there were 4 or 5 amicus briefs, and the Michigan Municipal League joined with the government law section on the case. I think MAP had an oar in the water. The real property section had an oar of the state bar, had an oar in the water. And all of the amicus briefs, and I was one of the authors of a co-author of an amicus brief in the case, and all of us agreed that on 2 things. One is that in order to have a valid proposal for a conditional use, a conditional rezoning, the use that was proposed must be permitted in the proposed zoning district. You can't have a use that's outside, otherwise you'd have this approval that it was granting rezonings outside of the district. And implicit in the ruling is the point that the use sought in the conditional rezoning must be more limited, not expansive, upon a use that is permitted in the zoning district. And so that's a major point. The end result in the case was that the court sent the case back to Mayfield Township for the purpose of determining whether the use they were proposing was part of the zoning district to which the land was proposed to be rezoned. And so we'll have to stay tuned to see what happens in that situation. Now, here is my last point, another lame duck session. We've been fighting the aggregate industry for the last 10 years on the ability to regulate, in other words, local control as part of the Zoning Enabling Act for gravel mining. And as many of you will recall, in 2011, actually 2010, there was a case, Casson Township, by Casson Township, Kaiser versus Casson Township, where a challenge was made to a rule that required a property owner to show that a proposed gravel mining would not result in a very serious consequence. Well, the interesting thing there was, number one, the Gravel Association wrote that bill, and it allowed mining in any district, which can be a problem. As soon as you start allowing mining in a residential district, then you're obviously creating difficulties. As over the course of a number of years, many gravel pits were established, but now, in fact, starting right almost immediately, the industry basically said that this, even though we wrote it, the industry wrote it, we don't think we went far enough when we wrote it the last time. And so now we actually want to take all local control away from local units of government, cities, villages, townships, and counties, and move it over to Eagle. And this is quite a bill that's present now and has been in lame duck. I think I've participated in 3 lame duck sessions opposing this legislation. But the bill, and they seem to be getting progressively worse. So in this particular bill, it allows Eagle to approve a permit, even if it would result in a public or private nuisance. This is something, I mean, the nuisance law essentially is like the bottom line, whatever you do from one property to another property or properties cannot result in a nuisance. And I mean, that's huge. But in this bill actually goes on to say that even if it's a nuisance, Eagle can approve the mining operation. In addition, they can approve a mining operation on property in which there's already groundwater contamination. And they can approve an operation with noise impacts believed to be at levels that would cause hearing loss. And finally, and although this isn't a total list of things, a complete list, Eagle can approve a permit without conducting a hearing, even if Eagle determines, as a result of comments that are submitted, that there's a sufficient public interest for conducting a hearing. They can just blow it off. So it's all it's kind of a strange situation that the bill proponents have drafted. I really question whether lawyers have drafted this. Not that lawyers know a lot more, but the idea of allowing a use that would result in a nuisance, that basically steps on centuries of law. And so obviously there's a reason for all local governments to oppose this legislation and do so aggressively and affirmatively by contacting legislators and taking all other measures that would be feasible. All right, well, I have come to the end of my prepared presentation and would look forward to any questions out there.
Excellent. Great job, Mike and Jerry. Appreciate the input. We do have a number of questions. First off, was there a master planning amendment that was independently approved, or was it tie-barred to other pending bills? And Mike, you already answered that in chat, but you want to go ahead for everyone's benefit?
Yeah, the housing bills led by Christian Grant from Grand Rapids, that's a 4 or 5 bill package, 60, 95 through 98. They're up in committee tomorrow. That legislation is not tie barred to any other bill packages. I'd have to double check to see if they're tie barred internally to each other, which is not an uncommon practice, which means that all of those bills would need to pass or all wouldn't. It says at the very bottom of the bills, it's more of a procedural thing. But that's worth mentioning, that those are not tied to any other areas of statute, and probably not expecting them to be.
Next question, is there any chance of repealing Public Act 233? There are 80 townships that signed on, with 5 of those being counties. Also, there are resolutions that every township can pass to support the lawsuit.
I think it's relatively unlikely you see a wholesale repeal of the act, in part because Democrats are still in control of the state Senate and the governorship, both of which supported those bills just a year or two ago. The flip side of that is it is something that House Republicans may try to attempt to change. So I think it's very possible that you see attempts to change it, potentially even having a negotiated change to it. The other thing that I'll mention about the PA 233 components is that we've got statutory requirements for a certain amount of renewable energy to be generated by a certain date. It's very difficult for utilities to hit those numbers without having some level of a siting, I hate to say preemption, but effectively a siting preemption, right? That they are at a certain number now for their renewable levels. They need to be here later. The only way to get from A to B is for them to probably have some sort of statute like that. So I don't see wholesale repeal. I do potentially see changes, but much to be discussed on that. And of course, there's pending litigation as well. So the answer is maybe.
Jerry, anything to add?
I would say this, that that if the legislature does not clarify certain provisions, I think the litigation that's pending would probably be taken up to the Michigan Supreme Court eventually.
Okay. All right. Next question. Any news on the septic bills?
They posted for committee tomorrow while we're on this call. So that's worth mentioning as well. The statewide septic code has been an item that's been long discussed. Michigan is, I believe, the only state in the nation that doesn't have a statewide code on that subject. And they are considering some pretty significant new statute for that. That's Senate Bills 299 through 300 and 300. They are going to look dramatically different than the introduced versions of the bills. There's new drafts that have been floating around of those. They pushed the timeline out pretty significantly to about 10 years, but the bills at a certain level do not address some of the underlying, how do I say it, concerns from local government, particularly local public health. So the way that the structure works is that local public health will be doing all of the implementing of that legislation. There's no discussion in the bills about fees and what they can charge for that. There's also not a lot of discussion about how inspections will be charged for and will work, and things like that. So I don't know if they get done this session, but understand this is not the first session those bills have been introduced, and they will almost certainly be back in future legislative sessions should they not get completed. It remains a priority for some of the environmental groups. I will say just the one thing I would flag from a wastewater perspective, there's been a lot of concern that the bills do not address treatment of septage. So obviously it's great. We want to have people get their system serviced and pumped out. And the question then becomes is where does that waste then go once it leaves your house? There probably is not enough treatment capacity at your local wastewater treatment plants to take all of this septage that might be generated. So that's been a big discussion from like the MWEA side, where they're talking about, hey, this is good policy. We really like it. It's good for the environment. We should be checking on septic tanks. Cool, but where do we now take all this septage and how does the funding mechanisms for that work? So I don't know if they get done, but they're certainly going to get a hearing tomorrow in Lansing, and I can drop the details for that in the chat.
As a follow-up to that, Mike, what's the positions being taken by the local health departments?
I actually don't know. They've been through probably, I think they're on their 10th draft of those bills that's being circulated with stakeholders. A lot of folks, I have not heard on where they're at yet. So I don't know.
Next question, will there be opportunities to testify on these matters in Lansing?
Yes. So a couple mechanisms. So the big question is always, how do I do this, or how do I know? I'd start by, you guys are probably members of U.S. Statewide Association for planners. You guys track a lot of bills through that. The Municipal League tracks a lot of bills, townships, SEMCOG. All these folks have bill tracking functions where they'll notify you, hey, call your legislator, hey, this is up in committee, things like that. You can subscribe on the legislative website to committee notices. That's a free of charge thing. I dropped the link in the chat, legislature.mi.gov. You can go to the House or Senate websites. It's house.mi.gov or senate.mi.gov. Very easy. You can sign up for notifications for committee hearings. You can reach out to the clerk on that notice that you get and say, hey, I'd like to testify on these issues. And then what will end up happening is you'll potentially get that opportunity. Sometimes at minimum, you get to submit a card. You can just submit a card of support or opposition or position. You can also submit written testimony to the committee as well. So if you wanted to send a letter and say, hey, reaching out from this municipality, here's our issues, here's what we see as good or bad, that's certainly an option as well. So many options for engagement. If you have a really good relationship with your own legislator, your state representative, they can even assist you in these things directly as well.
Now, it's a follow-up to that. Is that a little more problematic during lame duck, the marathon sessions and so on?
Timelines get shorter. So just understand that you're not probably going to get a couple weeks of heads up. You're probably going to get a day or 2 or 3. Everything gets more truncated. I'll also mention from a committee perspective that as time gets closer and closer to the end of session, there's kind of one rule you're not allowed to break with legislation. Jerry's going to laugh because it's the one that you can't get around in the Constitution, which is bills must lay over 5 days between each chamber. So as you get to the last 2 weeks of lame duck, particularly the last week, you won't you limit your ability to move things between the chambers unless they've already been acted on by one. So it's kind of a technical component. But as floor time increases, right, as they're moving more and more bills on the floor between chambers, the amount of time available in the day for committee meetings decreases. So this week, you're going to see a ton of committee hearings. Next week, you'll see some committee hearings. The following week, you won't see any. Just to understand the timeline and the progression there, just from a mechanics perspective of how things move through the legislature.
So Jim, just the intelligence on the ground for the gravel bills is that there'll be almost no time for allotted and allowed for people to speak at the Regulatory Reform Committee on the bill that may get scheduled this week. And so my strong suggestion is that people put something in writing and send it to one or more legislators.
Okay. All right. And don't have any more questions, but just a note from Andrea Brown, who's the director of MAP, indicating that meetings today with their law committee to prepare for a meeting on sand and gravel. And also that there is a letter going out today regarding the 4 housing bills that she would be happy to share. So Andrea, if you want to chime in either in chat or pop on and let us know how to get that.
Yeah, so we've been working closely with Representative Grant on the housing bills, advocating favorably for the most part on the work that's coming out of her office. Housing, of course, is a huge issue across the state right now. We have some issues. They've been responding very well to the recommendations that our law committee has been making for modifications to the bill. So we're really heartened by that, but I do have a letter that I'm happy to share. And it's just in a Word doc. I've literally been working on it this morning. And then, as Jim said too, we, our law committee, subcommittee on the mining bills is meeting today. And we do have a meeting with Representative Snyder tomorrow. And we will be getting, thank you, Jerry, for the heads up on how quickly that's going to be moving, and that, you know, we may or may not even be provided with an opportunity to testify. That's unusual. But of course, MAP has been testifying on all of these sand and gravel bills, every iteration, every few years that comes up. Also heartened, thank you, Jerry, that they may not really have much of a chance of getting through. Yeah, fingers crossed on that. They're bad bills.
Okay, so Andrea, should folks reach out directly to you on that?
Yeah, or I can send you the letter. I don't know how to make a link of this really quick and put it in the chat. So I'm not, I mean, the letter is not complete yet. I was literally working on it this morning, so it isn't PDF'd or final edited. But there's a meeting with Representative Grant's office this morning for all of the stakeholders. And then again, as Mike said, it'll be introduced. It's on, it's at committee tomorrow morning. It'll be taken up by the committee tomorrow morning.
Okay.
For bills.
Thank you. Thank you very much. And Jerry and Mike, maybe as a wrap-up question, a lot of the theme here is a movement by folks to try to reduce or eliminate local control. Maybe a 30-second comment from either of you on what's driving that bus.
I think you could look at a lot of different factors, and it depends a lot on the stakeholders with each individual piece of legislation, just from a big picture perspective. So, you know, when you look at sand and gravel, you guys are obviously aware that you've got a pretty powerful lobby out there pushing for those bills. They also have a kind of an interesting set of stakeholders, right? So you have labor, which is supporting those bills because they see it as jobs for their members. And you also have the business community supporting them because they see it as, you know, good for business. The flip side is you have environmental organizations opposing, along with local governments and water utilities and things like that. I can tell you from a politics perspective, it's not a great place to be if you're a Democrat between the labor lobby and the environmental lobby. But that's a good example of where you end up with some of these issues. It often depends on who's pushing them and sort of who's got their issues. I mean, we some years ago had the tree ordinance bill, which I participated in trying to kill with the municipal league in a lame duck session. I think that was probably 3 or 4 years ago now. So sometimes you have these bills pop up on relatively short notice. They have underlying issues with stakeholders engaged. And what I tend to find is it's always somebody trying to get around their local government somewhere, that they've had a problem with something, it didn't work out in their favor. Maybe they weren't successful in court, and they say, hey, you know what I should do? I should pass a bill. And that's what you sort of end up seeing quite a bit. And frankly, spend a lot of time on my end fighting in opposition of.
Okay, and I can just do a tag on to that is over the last maybe 20 years or so, there's been an erosion that has occurred, erosion of local control that has occurred. And the difference between the situation previously and the situation now is that in days gone by, when there was an issue that a private stakeholder had with regard to, like zoning, for example, rather than going directly to the legislature, what would happen is that either the legislature, if they did get it, they would kick it to the state bar organizations, like the real property section that would have an understanding of all this. The public lawyer section or public government lawyer section these sections would work with the stakeholders and hammer out a sensible reaction. And that's exactly how the Michigan Zoning Enabling Act was enacted in 2006. There was a lot of input on that, and then there was a comprehensive amendment of that later on, and the comprehensive planning bill. These were all worked out on a negotiated basis. So, but the local governments and the stakeholders had their oars in the water and could actually participate. But now it they goes directly to the legislature. The legislature takes the ball, and it's like local governments be damned, and the interests of local governments be damned. And when you say the interest of local governments be damned, that means the interest of residents and other property owners, even though a lot of people say property rights are being harmed. Well, the property rights of residential properties are being harmed. So the long and short of it is that one answer should be that when these issues come up where there is a problem, and let's just assume it's a legitimate problem, the best thing to do is to allow the planning association to be involved, and the county association, the municipal league, the township association, let everybody have a word and say, here's what's good for me, but here's the problem if you do this. And then it gets worked out in a way that has much less litigation and much less gnashing of teeth.
Oh, okay, thank you. And then one last, it's not a question, but Mike has posted in the chat a link to the committee notices for the House on the zoning bills. All right, Ryan?
Yeah.
That's it.
Really, both, thank you both to Mike and Jerry today for their insight and expertise. And I want to thank everyone else for joining us today. I look forward to seeing you next year at our next scheduled planners gathering on January 22nd. We'll have a presentation of the PACE program, the Property Assessed Clean Energy. It's a financing program that's facilitated through folks at Lean and Green, Michigan. So thanks again, everyone. Have a wonderful